Good morning, Mr. Geller.
Good morning, Your Honor. If it please the Court, I'm Roger Geller. I'm here on behalf of the Office of Bar Counsel. It is the position of our office that this case presents several important questions concerning the extent to which additional provisions beyond those that are listed in the contingent fee agreement form in Rule 1.15F, to the extent to which those would be permitted and under what circumstances the Court would allow extraordinary or extra provisions in a contingent fee agreement. Primarily, this case involves three termination provisions in the contingent fee agreement. The first one is a compensation rate that is greater than the fair value of the services rendered by the attorney.
May be greater.
It may be, but the language in the contingent fee agreement is
Because it's the greater of the two.
fair value of the services or the highest offer made, whichever is greater.
Is that also a contingency? Is there a second contingency in this agreement? Namely, if in the occurrence or in the event of a discharge of the lawyer, then this alternative fee agreement kicks in.
That's correct.
So there are actually two contingencies. One of them is if there is no discharge, then the other contingency is successful prosecution of the claim.
Absolutely. These are termination provisions. So the three provisions that Bar Counsel has problems with all involve the termination of the attorney-client relationship.
Does this agreement, this type of contingency fee agreement, does it comport with our rules?
Well, that's the question. It's our position that it does not comport with the rules, that this is a business. These three termination provisions.
I didn't understand that you were contesting the fee agreement itself. It seemed to me that, maybe I misread it, but it didn't seem to me that you claimed in the brief that you were contesting the fee agreement itself, apart from what he did under it.
What we are saying about the fee agreement itself is that by these three termination provisions, the fee, the lien on the recovery, and the pre-dispute arbitration provision, that those three convert this into a business transaction between a lawyer and a client. Ordinarily, fee agreements are not treated as business transactions under Rule 1.8, but these termination provisions transform this agreement into a business transaction.
Are you saying that a contingent fee agreement cannot provide an alternative form of compensation, namely an hourly rate, even in the event of a failure of the contingency?
We are not saying that, and clearly it can. This Court has held that it has approved contingent fee agreements that provide that. However, what we are suggesting is that Rule 1.8 requires notification to the client, an explanation of these provisions, perhaps in some circumstances the opportunity to consult with independent counsel, none of which occurred here.
But if you say that the agreement doesn't comport with the rule, that's a different story than saying that you have to consult, you have to explain it to the client and give client an opportunity to consult with independent counsel. That's what I don't understand.
Your point isn't so much that 1.5 is violated, it's that with this kind of agreement, it triggers 1.8.
Absolutely, that's true, yes. 1.5 allows for an ordinary contingent fee agreement. When you extend beyond that, other rules come into effect. It's not that it's per se not acceptable, but that other rules exist to protect the clients under these circumstances.
Mr. Geller, under the contingencies, if there had been no settlement in either of these cases, it would still trigger the contingency, wouldn't it?
It's our reading of this particular contingent fee agreement under the termination provisions, yes, it's List versus Student all over again.
That's what I thought. I mean, although nobody's really talks about that in this. Is that right?
This wasn't an issue that was addressed in either of the two briefs.
Okay.
That's correct. So what we are saying essentially is that by asking the client to give up substantial rights, the right to a jury trial, the right to pay compensation only upon the fair value of the services rendered, and to have only, to grant only the lien that is permitted by law as opposed to a separate contractual lien on the client's recovery, that the lawyer in this case was required to provide an explanation of these provisions and notice to the client, and to give the client sufficient opportunity to really understand what these provisions mean. There was a complete failure of that in this instance. The board and the special hearing officer found that the agreement itself was not so, the language in these termination provisions was not so complicated or not so complex as to require an explanation, a separate explanation.
Mr. Geller, may I ask you this? Let us assume that, maybe I misunderstood your answer to Justice Cowan. Let's assume that there is no settlement, and for whatever reason the case doesn't go to trial and there's no recovery. I mean, it goes to trial, but there's no recovery. But there was a settlement offer of, I don't know, let's just say $100,000. And under this fee agreement, he's entitled to 1/3 of that.
Arguably, that
Okay,
is,
so
I think that the agreement could be read that way.
Wait a
yes.
minute. So this client has received nothing, okay? But there was a settlement offer, and and the lawyer would be entitled to 33 1/3. And let's say that settlement offer was received on day 2 of representation. So the lawyer didn't spend more than 36 hours working on the case. Couldn't have done it, and even if his billing rate was $800 an hour, you can't get up to $33,000. Why is that not an excessive fee under 1.5?
I think it would be if it were
Have
challenged.
you made that argument? Have you made that argument?
I think that we did say in our brief that this has the potential to entitle the lawyer to an excessive fee, yes.
Well, so does a regular contingent. If that's true, so does a regular contingent fee agreement.
No, because a contingent fee agreement says that you get 1/3 of recovery. This agreement says you get 1/3 even when
Because of
there's
the
no
termination
recovery.
provisions, it's just the
But
highest.
are you saying that a $100,000 offer that's accepted
No,
and
not
paid
accepted.
out?
No, no, no.
I just want to make sure I understand. Are you saying that a $100,000 recovery after 2 hours of work is an excessive fee?
I'm not saying that it is. It depends on the circumstances, but any contingent fee agreement is subject to a reasonableness standard and subject to the review of the court on every instance.
But we've often found that
Yes.
of course, but as a general matter, there's no contingency fee agreements by their nature don't correlate amount of effort and recovery.
That's
It's a
correct.
risk-based thing. But I was positing where there's no recovery, but there was a settlement offer. But it's also, way more than the amount of time expended. Okay.
Yes, that's one of the concerns that we have about these termination provisions, that it raises a substantial possibility that the lawyer would be entitled to an excessive fee or a fee even if there is no recovery. And that would be inappropriate in Bar Counsel's estimation. We also think that these fees, these fee agreements, these provisions are unfair to the clients. The fee is more than allowed under existing law. Massachusetts recognizes the fair value of the services as the measure of compensation for a discharged lawyer, and yet this agreement seems to provide more than the fair value of the services to the lawyer.
They can go to another lawyer. They're not stuck with this particular client, are they?
Well-
or with this, the client isn't stuck with this particular lawyer. If they want this lawyer and don't want anybody else,
If that were the case, that's true. But still, this lawyer, in order to have a client sign and be a party to this contingent fee agreement with these provisions, has to point them out,
well,
has to
didn't
discuss
the hearing officer find that the clients, found that the lawyer did not make any of these explanations, the clients did not go to an independent lawyer for advice, but didn't the hearing officer find that the clients, both clients in this case, understood the terms of the contract?
He found that they read the terms of the contract, because the last sentence of the agreement is, I've read and received a copy of this agreement. And he inferred from the fact that they had read it, that they understood it.
Because they were he said non-complex.
He found them to be not complex enough to warrant the protections to clients that are afforded in Rule 1.8 and 1.4.
Did the clients ever testify that they did not understand the terms of the contract?
There was testimony from one of the clients' testimony was struck. The other client testified that he didn't, that he read it, he didn't really appreciate what it meant. And I think that it's not so much as understanding the words, because these words are susceptible to understanding, but it's the legal implications and the ramifications and the consequences of this language that is at issue. And I don't think that these clients, who were not sophisticated people, they weren't like the...
That makes a difference.
Absolutely.
All right, so how do you construct that into a rule? If it's a sophisticated client, these kinds of agreements are fine. If it's not, and just leave it to the court to decide who's sophisticated enough?
Well, I think this court has recognized that sophisticated clients are not necessarily, lawyers are not necessarily required to give the same kind of explanation to sophisticated clients that unsophisticated clients are entitled to. And but even in a case like the Cambridge Trust versus Hanafi and King, in that case where there was a sophisticated client, that client did have independent counsel, that client did get warnings from the lawyer, and so that even though it was a sophisticated client, when they were altering the fee provisions in that contingent fee agreement, that client got the benefit of the rules, whereas these clients are deprived of that benefit.
Do you think that Rule 1.5 should be changed to explicitly prohibit some of these provisions?
I think that if these provisions were to be included in agreement, they would have to be coupled with sufficient warnings to the clients that as to what they mean. I think some of these provisions are probably per se inappropriate. For example, the Board of Bar Overseers felt that it might be possible for a client and a lawyer to contract for a fee that's greater than the fair value of the services rendered upon discharge. That may be arguably so, but it doesn't seem right. But we have other provisions in contingent fee agreements now where a client can bargain with a lawyer if they're given the opportunity. For example, who's going to bear the responsibility for payment of costs? Or who's going to pay for an appeal if that happens? Those are provisions where a client should have some input if they are made aware of them by the lawyer, because again, most clients don't understand that those provisions are subject to bargaining. And without any explanation from counsel, clients are just going to, clients come in, they've been injured in an automobile accident, they want a lawyer to start their case right away. The lawyer says, here's my agreement, it says right in the agreement this is subject to Rule 1.5. Most clients are going to think that that is the language that's in this agreement is proper and it's been approved by this court. Whereas in this case, the language does not appear in the approved language that this court has approved. I would like to also just, again, emphasize that another issue that the board felt was arguably a problem was the 7-week delay between the time when the lawyer received PIP benefits for this client and didn't tell him about it, and then used those PIP funds to pay medical providers where the client had the expectation and the desire to have his PIP benefits applied to his lost wages. By paying them out without any notice to the client, the lawyer deprived the client of any right to have a say in how his PIP benefits should be applied. And the other, I rest on my brief for the other issues that we have with the manner in which this case was handled by the lawyer in this matter.
Thank you, Mr. Keller.
Thank you very much.
Mr. Bourgeois?
Thank you, and good afternoon, Your Honors. It's a pleasure and an honor to be here. With me is my partner, George Dresser. I'd like to begin by disagreeing with my brother. This contingent fee agreement is absolutely clear. At the language at the bottom of paragraph 6 and the reference to paragraph 2 and 3, there is no recovery to the first lawyer if the client is ultimately unsuccessful.
Even if there's been a settlement offer?
Even if there's been a settlement offer. The agreement says flatly...
But no recovery even for quantum merit?
If the attorney is discharged and the case is later unsuccessful, as I read this agreement, the first lawyer gets only his or her expenses and not any compensation, because it says at the bottom of paragraph... A little unfair to the lawyer, isn't it? Well, it is, but the nature of the reality is, in the personal injury case, frequently the client's not going to be able to pay anything other than out of a settlement.
Okay.
This is a contingency fee agreement, in other words.
Yes, sir, it is.
It is a contingency.
And it's contingent on the client getting some recovery?
Correct, and that's clear in paragraphs 2 and 3. There are no exceptions.
Could you tell me where that is in the record, by the way?
It's
yes,
page
sir,
169.
It is
169,
in appendix at page
got it.
173, and I'm referring to the end of paragraph 6, which says, "The amount of the fee shall not be due to the attorney until the subject matter litigation is concluded pursuant to paragraphs 2 and 3 above." 2 says, "No counsel fee shall be paid if there is no recovery," and 3 says, "The client is not liable to pay compensation otherwise than from amounts collected, except as follows," and it says, "no exceptions."
So there's only one contingency in this contract, and that is successful recovery.
Yes, sir.
Now, what happens if the recovery is $10,000, but before your client was terminated, he received a bona fide offer which was communicated to the client for $100,000?
In that situation, there would be arguably an entitlement to
$30,000.
$30,000. But we have an overarching obligation under Rule 1.5, which this agreement incorporates at the end, that says the client shall never be charged an unreasonable fee, and that would probably be an unreasonable fee.
Well, it might or might not if your client had put in a lot of time, and then for whatever reason there's a client conflict, and the client, not the lawyer, the client decided to go to another lawyer who wasn't as good, wasn't as successful, decided to go to a jury in the face of a settlement offer. The insurance company decided to throw their big guns at it, and the jury gave them a de minimis amount. I mean,
I agree. And all of us can hypothesize a number of situations where an innocuous contingent fee agreement at the outset results in an unreasonable fee. It can happen.
well, again, there's an overarching thing that it can't
Yes.
be unreasonable, and I forget the name of the Worcester case. I think Justice Glenn wrote it, that where there was a huge fee with almost no time and expenditure, and I think we actually upheld it. I'm not thinking about the Hannafin King case, but in an earlier case, I forget what it is.
I'd like to talk briefly about what I'll call the wisdom or the policy of enunciating new standards about contingent fee agreements through the disciplinary process. Remember, we deal here with a case where this fee agreement was understood by all the clients.
Did the hearing officer find that specifically?
Yes, sir. It appears in the hearing officer's report at 2 paragraphs. With respect to Gallant, it is at paragraph 102, and with respect to Fairfield, it is at paragraph 169, and he also found that with respect to the Fairfields, Mrs. Fairfield had had a prior case, and they had used the same contingent fee agreement. It was also undisputed that all of these provisions that my brother quarrels with have their source in recognized texts, form books, publications of Massachusetts continuing legal education, and the MBA. Literally, the fee arbitration provision that he wants you to say is a disciplinary violation is the recommended language of the MBA model fee agreements.
But the board did not go that route, but did discipline your client because of things that's hard to argue that she shouldn't be disciplined for, isn't it?
I'm sorry, I didn't understand your question.
Well, I take it that the board's admonition was based on...
The failure to...
The board's admonition was based upon my client's misuse of a form letter. He sent a form letter out to an insurance adjusters in 2 instances that said, I have a statutory lien and a contractual lien, when in fact he only had a contractual lien. However, I point out to you that when you're using Rule 8.4, which talks about conduct involving dishonesty, deceit, misrepresentation, and unfitness, the single justice made a decision to defer to the hearing officer, who saw my client in front of him for 14 days, and defer to that decision about the issue of was this a mistake or was this in fact conduct involving dishonesty or deceit. And that can't be an abuse of discretion. The single hearing officer...
Can I ask you this question? It's me, Mr. Bourgeois. Your client runs, a substantial practice and has a number of paralegals and secretaries are doing that. What obligation do we impose? And I suspect, although again I haven't looked at the testimony before the hearing officer, that your client himself didn't. He may have signed the letter that went out to the insurance company, but I suspect that a paralegal, or if not a secretary, sent it out. Correct?
Well, there was testimony that in each instance when he sent out that letter, there was a call ahead of time to the recipient, who was an insurance adjuster. And one of those insurance adjusters testified, and he said, I wasn't misled by the letter. I understood that Mr. Cariglia had a contractual lien, and I don't even know what a statutory lien was. And so what happens is, yes, a paralegal sends out the letter, but it's preceded by a telephone call to the adjuster.
From the lawyer?
Yes, ma'am.
Okay. Second thing is, what do we do about the fact that he didn't tell his client that the PIP benefits had been received?
That is addressed in our brief, and it's an allegation by bar counsel that's simply not supported by the record.
Oh, but the reply brief does a pretty good job at showing that inferentially the hearing officer did find he didn't tell him.
Well, but the client was in the office within 6 days of the check coming in to get the amount of the net amount of the check. What's important to recognize is the rule doesn't actually say notify the client when you get money. What it says is if you have money that belongs to the client or a third party, notify the client or the third party. In this instance, there were 2 lien holders, 2 medical care providers, for which Mr. Fairfield had signed authorizations. They had a lien. They were entitled to that money. And Mr. Fairfield came in about 6 days after the check was issued. There was a calculation made of the amount that wasn't lien that could be given to him. Attorney Gentili of the office testified that she explained that to him, and the balance could not have been legitimately given to him at that time. The health care providers had conflicting claims on that amount too, and so that couldn't be determined until much later. Part of the issue, and this sort of circles back to the issue of the complexity of the arbitration, notice that in all of these cases, the clients are signing forms in the doctor's office giving the doctor's liens, but somehow they can't go into a lawyer's office and give the lawyer a lien for the lawyer's service. That doesn't make a lot of sense to us.
Well, it might to us.
I understand, and I understand that.
We don't discipline doctors.
One of the points that Mr. Wright, who was the chairman of the MBA fee arbitration program, testified is he made it very clear. He said, I want to make it clear, I think every lawyer should use a written fee agreement, and every lawyer should have an arbitration clause. And so when I send Mr. Dresser to review my fee agreement with a new lawyer, who reviews that lawyer's fee agreement? If everyone's using arbitration clauses recommended by the MBA, the very concept of referring someone to another lawyer just doesn't work. There's nothing inherently complex about this. Again, all of these have their sources. This is the MBA recommendation. The alternate measure, and it's not a trigger, it's a measure of
The arbitration is not the rest of it, right?
Correct. And remember, the arbitration works both ways. The lawyer is giving up a right, too. And in this very case, this arbitration agreement was imposed against my client. When my client complained in the Superior Court about the fragmentation of the $20,000 settlement for purposes of circumventing his lien, Judge Agnes said, sorry, that's a dispute about a fee, and you're going to arbitration with it. And so it works both ways.
But what about the failure to provide information about the time spent in the Gallant case after she went to another lawyer and the lawyer requested an accounting of the time spent? I know there's a question about whether or not the rule even applies in this case because the contingency hadn't occurred, but is that fair?
Well,
the lawyer wouldn't turn that information over that's sort of vital to negotiating a new contingent fee agreement with the new lawyer?
I think this court answered that question in the Malonis and Harrington case when you said there may well be good reasons for a lawyer to not submit an invoice until the case is finally settled. In this instance, when the case was finally settled, it was settled in conjunction with the Board of Bar Overseers' complaint and a lot of acrimony. And that was unfortunate that happened, but it happened because, as the hearing officer said, this was really a dispute, lawyer versus lawyer, but the second lawyer...
How is it a dispute, lawyer versus lawyer? Was there a fee-sharing agreement between the two lawyers?
The lawyers cooperated immediately to...
No. Was there a fee-sharing agreement between the two lawyers?
No, sir. No, sir.
Isn't that significant?
No, because we have a fact found that the client was isolated from the fee dispute. The lawyers cooperated immediately to endorse the check, to get the fee escrowed, and the client got her money and got it right away, which is what this court said we're obligated to do in Malonis, and we did it before Malonis came out.
But the client was, at least theoretically, exposed to a lawyer's fee that was in excess of the original contingency. I can't remember, was it 1/3? Because she could have signed a 1/3 contingent fee agreement with the successor lawyer.
Yes.
Ended up having to pay the successor lawyer 1/3 of the amount recovered, plus the amount of the fair services that this lawyer rendered.
And I agree with you theoretically, but the undisputed evidence here is that what we did in this situation was essentially to foresee this court's rule in Malonis versus Harrington, and that is that the client expects the lawyers to work it out themselves. That's what you said, and that's what we did.
But you exercised damage control. The lawyer in this case did not have a fee agreement that provided for that sort of thing. In fact, specifically provided for reasonable time. In this case, it would have been reasonable, the fair value of my services.
I'm not sure I understand. You're talking about the first lawyer or the second?
Talking about the first lawyer, and then she would have been responsible for paying 1/3 contingent fee to the second one.
Wasn't the initial request of your client for 1/3 of the whole settlement, not some portion of the 1/3 for the fee?
The testimony of Kathleen O'Donnell is that she said that in 99 out of 100 cases, in her experience, where there's a successor lawyer, there is an agreement or understanding to give the lawyer 1/3 of the fee. We did ask for that.
You asked for 1/3 of the settlement, didn't you, in the first instance?
No, 1/3 of the fee.
This is you're talking about an after-the-fact resolution between the two lawyers.
Yeah.
You're talking about damage control. You're not talking about the terms of the original agreement.
I'm not sure I understand your question, so I'll just, if I can answer what happened. The Gallant case was finally resolved. There was discussion about what amount of compensation should be paid to my client. I made the suggestion in a letter to do what Kathleen O'Donnell says she does in 99 of 100 cases, and that is we'll take a third of the fee. In that case, it was, I think, $1,500 or something like that, or $2,200. It was a third of the third, treating it almost like a referral. That was rejected, and what the hearing officer said was that was not a demand, that was a compromise solution suggestion, and there was nothing wrong with it. And instead what happened was that matter went to fee arbitration where it should. And so there's no issue there. With my last few moments, again, I want to just emphasize on the limited issue where the single justice reinstated the decision of the hearing officer. The special hearing officer was a former chairman of the Board of Bar Overseers, Mr. Costello. He saw the witnesses and saw the respondent for 2 weeks. It could not be an abuse of discretion to uphold his decision about whether any conduct was dishonest, deceitful, or reflected on fitness. On that, I submit on the papers. Thank you.
Thank you, Mr. Bourgeois.
All right.